Joining me now is Father Frank Pavone, who is the head of Priests for Life, and I'm delighted to have him here as we talk about this stunning decision yesterday by the Supreme Court that essentially has put women at risk, and a shocking ruling. Father Frank, thanks for joining me. What was your reaction when you heard that John Roberts had sided with the most liberal members of the court in shutting down Louisiana's, frankly, very sensible law?
Yeah, it's very disappointing, and it's very disappointing for the women that this law is trying to protect, because he's talking about precedent. There was a decision, as you know, 4 years ago about a very similar law trying to protect women in Texas from what we know is an unscrupulous, unregulated abortion industry. And actually, the Chief Justice voted the right way in that case, but he was in the minority. So because the case now constitutes a precedent, he's going along with it. But as we know, the Supreme Court is not bound to follow their own precedent. Lower courts are, but that's vertical precedent. But horizontally, the Supreme Court is completely free to revise or to completely reverse previous precedent.
Let's talk a minute so we make sure that everyone understands what the Louisiana law did. It simply said that an abortion doctor had to have medical privileges at a medical facility within 30 miles of the abortion clinic, so that if something went wrong, and let's say the lady having the abortion was bleeding profusely and at risk of death, he had to have admitting privileges to a hospital nearby to save her life. That's not uncommon for any outpatient surgical procedure. In fact, it's pretty much mandated. But the abortion clinics were not made to follow that same type of medical protocol.
That's right, Governor. It was not a big ask at all. It's already in place in Louisiana. Other ambulatory surgical centers require this kind of hospital admitting privileges, and for good reason. Number one, we have a long track record in Louisiana, as we do in, unfortunately, just about every other state, of abuses, malpractice, shoddy and unsanitary and unsafe conditions in the abortion facilities. So that's number one. We have in the court record, for example, women being sent home from these abortion clinics in Louisiana with the head of the baby still inside of them, or bleeding and in pain. And having hospital admitting privileges, first of all, allows what we call continuity of care. So if there's an emergency and she has to be brought to the hospital, the same doctor that was working with her before continues to provide care. But secondly, also, it's the credentialing of the physician. These abortion facilities in Louisiana were hiring abortionists, first of all, who were not trained in abortion. They had ophthalmologists and radiologists doing abortions. Also, they were not doing background checks, which the hospital admitting privileges process would in fact do. And thirdly, there would be continuous monitoring of the credentialing of that physician, rather than just an annual form you fill out and fee that you pay. So there's a need. The legislators of Louisiana assessed that need. They addressed it for the health and safety of women. Even Roe v. Wade, almost 50 years ago now, said that although we're making this procedure legal, the right to abortion is not absolute, and it has to be done in circumstances that maximize the health and safety of the woman. So what Louisiana did was completely reasonable, constitutional. The Supreme Court should not be judging the wisdom of the law. They can look at the constitutionality of it, but what they're trying to do is second guess the legislators in Louisiana.
I think it's important to note that that was a bipartisan bill in Louisiana. It was passed with Democrat votes, signed by a Democrat governor. So this was not a partisan political issue for Louisiana. And as you mentioned, this is a bill that the Supreme Court certainly can compare the Constitution to it. But what they did yesterday was they legislated. They might as well have taken off their black robes and said, we're running for Congress, because they created a prescription rather than simply apply the law to make sure that it was constitutional. That troubles me, and I'm sure it does you.
It's very troubling. And you know what it shows? It shows the unworkability of the standards that the Supreme Court has tried to apply to abortion over all these decades. In the dozens of cases that have come down since Roe v. Wade on abortion, we've been looking at shifting sands. We've been looking at a conclusion without a rationale. They don't know how to justify this. And most recently, the court has been expecting of the states an analysis of undue burden, as they call it. Will this regulation on abortion that the state has create an undue burden for a woman to get an abortion? Well, the problem with a standard like that, aside from the fact it's being invented out of whole cloth, is that there's no definition of when and how a burden becomes undue. When that standard was first given to us back in '92, the court made it clear we're talking about substantial obstacles. We're not just talking about an inconvenience or a little bit of extra time or trouble to get the abortion. We're talking about a substantial obstacle. Well, in this decision, the court turned that on its head. And now what they're saying, and this shows the extremism of the abortion industry, what they're saying is the slightest little burden on the smallest number of women that might be affected is enough reason to throw the whole law out. And that is just so completely unreasonable that people should see this for what it is. It's an abortion industry that wants this right to be considered absolutely fundamental and sacrosanct, to the point that you can't permit the slightest inconvenience. It's got to be like, okay, someone wants an abortion, you're going to part the Red Sea, and not let there be any hindrance whatsoever. That's just unreasonable.
Sometimes, Father Frank, I think I'm living in Alice in Wonderland, because all of these things are celebrated as a victory for women's health. Well, there's nothing that helps women to have better health if she's being treated by a doctor who is not licensed to admit her to a hospital should something go wrong, and is not subject to the same type of rules. I don't understand, how can we change even the rhetoric so that people will understand this issue of abortion is not a women's health issue. It's certainly not healthy for the baby, but an abortion is a serious surgical procedure, not very healthy for the woman either.
I have always maintained it's not an aspect of medicine, because a medical procedure helps the body to do what it's supposed to do, but is having trouble doing. Abortion is just the opposite. The body is doing what it's supposed to do as it's nurturing that baby, and it's doing it just fine, and abortion comes in and stops all that. I think in answer to your question about how we begin to change the rhetoric, change the thinking of all this, is that we need the voices of the women who've had abortions. And as you know, our associate here at Priest for Life, Alveda King, and I and Janet Morana, we helped to oversee the Silent No More campaign. And the Silent No More campaign actually had a voice in this case. As a matter of fact, Justice Alito, in his dissent, references the amicus brief that we submitted to the court, which contained the voices of the women themselves, some of them from Louisiana, who have had abortions and who testify. And we had them, by the way, in front of the Supreme Court on the day before the oral arguments. We had a rally that lasted the whole morning out on the steps, and they were sharing their stories one after another. And they made it very clear we were not treated the right way by these abortionists. They do not have our best interests at heart. We were devastated by the abortion process. We carried emotional and physical wounds afterwards. Their voices need to be heard so that we can concretize this. So it's not just some kind of abstract debate about women's rights and women's health, but so that we can hear what they actually went through and how they actually suffered later on. Their voices are important also, as Justice Alito pointed out, because the irony here in this case is that it is the abortionists being regulated by this law who are marching into court to complain about it, not the women whom the law is meant to protect. Not a single one of them complained about the law. It's the abortionists complaining about it, and they're saying to the court, oh, but we represent these women. And that was the other big issue in this case, as you know. Not only was the court looking at the constitutionality of the law itself, they were looking at the constitutionality of whether the abortionist could be there representing the women. Now, they said yes. However, that contradicts the past jurisprudence of the court on this issue, because to have that kind of third-party standing, you're really supposed to be in a situation where you have a close relationship with the person you're representing, and the person you're representing can't speak for themselves, and neither one of those things is true, and you have to have their best interest at heart. So these women were saying, look, our experience is the opposite of all that. There's no close relationship. They don't have our best interest at heart. They're harming us. They don't speak for us. And this is how we have to begin redefining this debate.